Good afternoon, everyone, and thank you for joining in early. Please allow us, as we wait to start, to test the systems with the speakers. I can see Dr. Naomi is here with us, and I can see Advocate Cindano is also here. So perhaps just to allow us to test systems, and we will start promptly at 3. Dr. Naomi, you there? Advocate Cindano, can we see your faces? We can see you. That's great. How are you?
That's me. Oh, hi.
Good to see you.
Good to see you too, Dr.
And we can hear you too, so that's a good thing.
Excellent.
Yeah, Naomi, are you there?
Great. Yeah, I couldn't unmute myself before.
Yeah. Oh, excellent.
Yeah.
We can see you too. We can hear you too.
Yeah.
Okay. All right, great. So we will wait and we'll start promptly at 3.
Great. Thank you.
I am masquerading as the moderator. I'm not the moderator. He'll be taking over shortly, but we are starting at 3. Yeah. Karibuni, everyone else. And as I said, thank you for joining early. We will be prompt in starting. We'll start at 3. Good afternoon, and a very warm welcome to all of you. Thank you for joining in time. We will be starting on time, so kindly wait. We will be starting on time. A very warm welcome to each of you. Karibuni. Good afternoon, everybody, and karibu sana. Welcome to this webinar, which is organized by the University of Nairobi, Faculty of Law, Mombasa campus, and the Mombasa Law Society. I am not your moderator this afternoon. Our moderator is having a few technical challenges, but he will be joining us in a few minutes. As we wait for him, I request our technician to play the national anthem as our starting activity. Mwangi, please, national anthem.
O God of all creation, bless this our nation. Justice be our shield and defender. May we live in unity, peace and liberty. Plenty be found within our borders. Let one and all arise. Bring our strong and true. Service be our honest endeavor. And the homeland of Kenya, heritage of splendor, from where we stand to defend. Let all with one accord, in common united, build this our nation together, and the glory of Kenya, the fruit of our labor, fill every heart with thanksgiving.
Thank you very much, Mwangi, for the national anthem. It reminds us of the prayer as a country. It's a rich national anthem and a good prayer that reminds us of our aspirations as a country. Once again, may I take this opportunity to welcome you to this webinar. As I said, it's organized by the University of Nairobi, Faculty of Law, Mombasa campus, and the Mombasa Law Society. It is one of the webinars in the public lecture series. We have been carrying public lectures throughout the year. And for this October, we have this webinar on mental health. And we'll start off by requesting our Vice Chairperson of the Mombasa Law Society for her remarks. Karibu Christine Kipsang.
Thank you, Dr. Sarah. Good afternoon, all of you. I'm so glad that you are here in this webinar. It is a good conversation we're going to have on mental health. The other day, I was doing a seminar on internet governance. And one of the principles that govern internet and how it is used is internet is for everyone. And I believe this topic that we have started on mental wellness, mental well-care, it is for all of us and for everyone, so long as you are a human being, so long as you are part of the human race. And so I welcome each one of you from, it doesn't matter whether you're from Mombasa Law Society or around the world, you're welcome because we practice openness and we love visitors. So welcome, collaborate with us in many of the seminars that will come by. And for the presenters for today, that is Dr. Naomi Njuguna and Mr. Cindano Gakuru. I just want to welcome you to this collaboration and feel at home as you share your topic and you pour your heart to all of us. Thank you so much and feel welcome. Thank you, Dr. Sarah Kinyanjui.
Thank you, Mrs. Kipsang. I do not know whether our moderator is now in. As I mentioned, he was having technical challenges. Asige, are you in? Right. So please allow me, Mr. Asigi, are you in? Sorry.
Sorry,
Oh,
Dr. Sarah, I
great.
actually admitted him, so I think he's in.
Yeah, great. Over to you, Mr. Asigi. Glad to relinquish the moderation. Over to you.
Hello, can everyone hear me?
Yes, we can. Thank you.
Good afternoon, everyone. I am so sorry. I had some technical challenges. I'd like to thank Dr. Kinyadu and Mrs. Tan for holding that I sorted myself out. As you have been informed, this afternoon, we are very privileged to have Dr. NaomNaomi Njuguna and Mr. Cindano Gakuru, who will be talking to us on the topic of exclusion in the legal profession, unpacking mental health law and policy in Kenya. But before we invite them to give us their presentations, I'd like just to go over some short house rules with all the participants. First of all, thank you very much for joining us this sunny afternoon. From Mombasa, Karibuni, Asanteni sana. So our house rules are very brief, but very easy to understand and comprehend and follow. So I hope you will bear with me as I go through them very quickly. So for those with panelists' rights, kindly keep your microphones muted unless you're giving an address. Participants will be muted for voice during the presentations, but we will be able to put comments, questions through the platforms, that is Facebook, Zoom as well. So please feel free throughout the presentation to give in your comments and questions, as we will have a plenary at the end, and we'll be able to put the questions forward to our presenters to answer. So those joining us on Zoom, please use the Q&A function to ask questions, and also the chat function. This way it will be easy to identify the questions and put them forward to the speakers in this case during the plenary session. Remember to include your name and where you're coming from, where you're joining us from rather. And those on social media, that is Facebook, which is on live as we speak, please begin your statements with either the word comment or question so that our team can be able to identify and bring your questions forward accordingly. Again, please include your name and where you're joining us from. As for the plenary, we'll do our best to have as many questions answered as possible, though we'll have to be mindful of time so as not to overshoot the allocation that we have. We are streaming this session, as I've said already, live on Facebook and on YouTube, and the recording will be made available after the presentation. I'm also encouraged to continue to interact with the presentation, with the question, even after the presentation, so we can have a lively debate as we move forward. Please also note that this meeting is being recorded. This webinar is being recorded. So make the necessary arrangements for those who might not want to participate in a recording webinar. Also, I'd like to just acknowledge the team, Mombasa Law Society and University of Nairobi Mombasa campus, who have worked together, who have included also advocates in Mombasa, students and lawyers in training, and faculty members, to be able to bring you this webinar today. So it's my pleasure to welcome you today. Please engage, use the social media, and keep the discussion going. So without further ado, I would like to introduce our first speaker today, and that will be Dr. NaomNaomi Njuguna. To the floor, Dr. Njuguna, the floor is yours. Thank you very much.
Okay, thank you very much, Kelvin, and the organizers of this event. I don't know if I'll be able to share my screen. Let me just attempt. Okay. Okay, I'm not sure if my screen is showing. Has it come up?
Yes, it is.
Great, thank you. Okay, good, right. So thank you very much for this opportunity to give this presentation today. As I was, thinking about this particular topic, I realized that, there are actually two separate issues that this particular topic brings out. And maybe I would ask the organizers to have, this would be part one, and then, there'd be a part two, because I don't think we'll be able to do justice to all the issues that are going to be raised, and you'll see why. I think there's the first part, which is mental fitness and exclusion in the legal profession. And then there's this other part of unpacking mental health, and unpacking mental policy and legislation. And I think that's a whole discussion on its own, because when we talk about mental health, we're talking about many issues. We are looking at mental health as an aspect of the right to health, and state obligations, with regard to accessibility, affordability, availability of mental health services. We're talking about the human rights of persons with mental health challenges, issues of detention and abuse in institutions. We'll be talking about, financing, autonomy, legal capacity. And I think one of the things that when the vice chair talked about internet governance, what came to mind is, mental health and the youth, and particularly in the digital space, with a lot of, youth going onto social media and being influenced, by social media and how it's affecting mental health. So there are so many conversations that can take place around this. But today, I want us to focus on one aspect of the conversation around mental health, and this is mental health in the workplace. And so if you look at the key words in this topic, mental fitness, exclusion, those two words would really feature in the workplace, and particularly now we're focusing on the legal profession. So today, and please warn me if my slides are not moving, so that I can know whether there's any technical issue. So today's presentation will just focus around, some introductory remarks. We want to then situate our discussion and differentiate between mental fitness and mental capacity. And then we will look at mental unfitness as a ground for exclusion in employment, based on the concept of inherent requirements of the job, and also the concept of reasonable accommodation. And then we'll look at the gaps in policy and law and the way forward for us. Now, the reason we are, talking about this, I think, is one of the things that we need to think about in the legal profession is the issue of, the inherent requirements of a job, and whether, mental fitness is an inherent requirement, and whether then an employer within the legal profession can actually lawfully discriminate against an applicant or a continuing employee within that workspace to exclude them from working, or to to not hire them or to actually fire them, you know, based on this. So that's why I say the conversation is really wide. Today, we will only cover that particular facet of employability within, you know, the legal profession. So it's a live discussion. Mental health and well-being is a live discussion. And especially now with the COVID-19 pandemic, it is a hot wire, you know, and we need to actually discuss it and really talk about the issues that are coming out. A mental health task force was established in 2019 under the auspices of the Ministry of Health. And the report, which is readily available even on the internet, urged the government to declare mental illness a national emergency. Okay, whatever that means, because they didn't really define it, but they said it's a national emergency. But to be honest, I don't see, you know, the government taking it as that, you know, as a national emergency. That's a conversation for another day. But the national emergency, I think, comes from the fact that 1 in every 4 people who seek healthcare in facilities suffer from some form of mental illness. I think these statistics are quite worrying, you know, and each of us seek healthcare at one point or another. So 1 out of every 4 of us, you know, would be having a form of mental illness, which is approximately 4.7 million Kenyans. The most common, of course, are the ones we know about, the bipolar disorders, schizophrenia, depression, and maybe depression, I would say major depression, you know, the ones that, you know, would cause somebody to perhaps not be able even to work. Psychosis disorders as a result of substance abuse are quite common. But then the disaggregated data also shows that the professions that are likely to be affected or to have mental health challenges are health workers, teachers, and here I would also put lecturers, because I'm a lecturer at the University of Nairobi, disciplined forces, the police, the army, the armed forces, and lawyers. You know, lawyers are also within that category of those who are likely to be, have a lot of mental health issues. So let's situate our discussion today. And as I said, mental health can be discussed from various perspectives, but the one that I want us to focus on is mental health and the employability of persons with psychosocial disabilities or mental illness. Yeah, and what is happening in reality and what the legal position is regarding the liability of an employer for discrimination if they are faced with an applicant or an employee in this category. So the discussion really is a transdisciplinary one. I see health law, I see a bit of labor law, I see disability law, I even see equality law. So the discussion is a very transdisciplinary one. And so any policy or legislative reforms and interventions have to have this collaborative approach amongst all these sectors. Yeah, so we will see how that comes out. So let's start off. Mental fitness. And the question is, do we talk about mental fitness or do we talk about mental capacity? Yeah, and I'm being deliberate about this because, for instance, in the Constitution, one of the grounds for removal of a judge is the issue of mental incapacity. And we want to know, is this the same as mental fitness? To my mind, and from my experience and from my knowledge, the two terms are not supposed to be used interchangeably. We use them interchangeably. In fact, when we talk of mental fitness, what comes to mind is we're talking about mental capacity. But we shall see that these are two different things, because mental fitness is the ability of workers to perform their work without risks for themselves or other workers, other employees. So it's a parameter. Mental fitness is a parameter that relates mental health or mental illness to working conditions, okay? And the assessments for mental fitness differ from those of mental capacity. I'm going to define mental capacity in a short while. So mental fitness, at least within the working environment, focuses on the job requirements, whether this person can actually, mentally process and mentally achieve the job requirements. So it's not really an issue of looking at the medical diagnosis, getting medical reports about this person. And then the assessments for mental fitness would actually sometimes, and in many cases, require an assessment of the actual working environment that this person is in, because the working environment can actually affect mental fitness. So if you're in a highly stressful working environment, for instance, healthcare workers, or if you are even a young lawyer who is being maybe sexually harassed, by a senior in a law firm, that is an environment where there's high stress and which would affect your mental fitness for that work. What about the issue of relationship with colleagues, or the number of working hours, or workload, or even the job location? All these are issues which cause stress and mental issues. I'll give an example, maybe not from the legal perspective, but in Kenyatta National Hospital, a study was done where the rate of stress is actually at 95.8%. Stress. Now, if you look at what, in fact, it means that that worker has gone from being tired to being fatigued to being, indifferent, to the patients because of the tiredness they're facing. And now they're totally stressed and going into issues of depression and things like that. 95.8. So the issue is that if you look at that particular worker, and you do a mental fitness assessment, you may find that there is a challenge there, but it is because of the working environment, not necessarily because of something inherent within that particular employee. So mental fitness would depend on working environment that the employee is subjected to, rather than on mental incapacity that the employee would suffer from. So this understanding of mental fitness, and I'm glad that the organizers use the term mental fitness rather than mental capacity as a topic, is very significant for our discussions today. It's not a common parameter. Sometimes that is assessed for purposes of employment, particularly in the legal profession. Most law firms will not insist on a medical report, even of fitness for work, leave alone mental fitness, even physical fitness. You just attend the interview.
Dr. Njuguna?
Yes.
Sorry to interrupt. The slides are not moving. I don't know if you've noticed.
I haven't noticed. Let me try again.
My apologies. Sorry to interrupt.
That's fine. Thank you for, I actually said that so that I can, I don't know why my slides don't move, but let me try again and see if it will work this time.
Thank you, Dr.
Thanks. Okay, but were you listening?
Oh no, we could hear everything you said. We had everything you said.
Understand. Yeah, we are so dependent
hanging on your every word.
Yeah, thank you. All right, let me try one more time. Okay. All right. Hiya. You message.
Yes, absolutely, absolutely.
Great. Let me just do an experiment and move to the next slide and see if it will move.
Yes, it's moving now. Yeah, it has.
Great. Okay, so Kelvin, please be my guide in case it doesn't move. Yeah.
No problem. No problem, Dr. Njuguna.
Thanks.
Thank you.
Yeah. So as I was saying that, most even law firms would not insist on a medical report of fitness. They would just do the interview, and assumptions are made at the interview level from a prima facie engagement with the interviewee. So if the interviewee looks fit, they look able, they've done their maybe some aptitude tests and things like that, then they're ready. You know, they have passed the interview and they can work, right? So mental capacity, so that's mental fitness. Now, mental capacity, and I thought to make this distinction, is it relates to the ability of a person to make decisions for themselves. Yeah, and this depends on various factors, such as the ability to understand the information that is given, the ability to remember the information that is given, and to make decisions based on that information, and then to communicate that decision. So a lot of mental capacity discussions you will find are around issues to do with medical decision making or succession and, you know, wills and things like that, and to check whether the capacity of this person is present in order for them to make a decision for themselves. And if they are not, then somebody else would be appointed to make those decisions for them. Yeah. So I just thought it would be important to make this distinction, and maybe even one day when this constitution is changed, to remove the issue of incapacity and talk about fitness rather than capacity. Great. So let's look at mental fitness as a ground for exclusion from employment. Kelvin, you're my time bearer, so you let me know how much time I have so that I don't overshoot. Yeah, great. So what does mental fitness as a ground for exclusion from employment mean? So the first thing we need to note is that mental fitness can actually be determined by a mental illness, or what we call a psychosocial disability, or an intellectual disability. These two are different. Psychosocial and intellectual are different. Intellectual has to do with learning and understanding and processing information and problem solving, social skills, communication, right? And it's usually not treated or managed by medication. You know, this is a condition that is there, but the person can cope and participate in community life with the right kind of social support, you know, as opposed to a psychosocial disability, which is caused by mental illness, and it affects the emotions, the moods, the judgments, perceptions, and behaviors of that person. Now, a psychosocial disability is not necessarily affected by and does not necessarily affect the intellectual capacity of a person, right? And it can be temporary or lifelong. Yeah. And it can be treated or managed by medication and psychosocial support. Okay. So there are these two different issues. And when an applicant or an employee is within a working environment, it is important for the employer to distinguish, you know, between the two. Right. So in this presentation today, we are concerned with mental fitness that is affected by psychosocial disabilities or mental illness. Okay, and I know that you know, we have all interacted at one point with the definition of a disability. I think what we need to note there is that mental, psychological impairments are considered disabilities, yeah? Because they impact the person on their social, economic, and environmental participation. And that impact is adverse, you know, it's a challenge to this person. Right? So it's a disability. So for mental illness to be registered and classified as a disability, the individual actually has to be subjected to various assessments. Yeah, it's not automatic. that if you have a mental illness, then you would be termed as a person with a disability. You'd actually have to go through the necessary assessments, and it would be safe for somebody to actually be registered with the National Council of Persons with Disabilities to, protect your disability status. So the question for us then is, would it be lawful for an employer in the legal profession to refuse to hire an applicant or to fire an existing employee based on their psychosocial disability or mental illness? Is it lawful? Yeah. And the lawfulness we shall see is based on the issue of inherent requirement. I'll send this presentation to members so that you can look at the various international provisions that employers would need to have in mind as they make these particular decisions, which are anti-discrimination of persons with disabilities. Yeah, the UNDHR, the International Covenant on Economic, Social, and Cultural Rights, the Convention on Rights of Persons with Disabilities, which is the main one, and of course the ILO Discrimination, Employment, and Occupation Convention. For the domestic provisions, we have the Article 27, Article 54 of the Constitution, Section 5 of the Employment Act, and of course, Section 12 to 15 of the Persons with Disabilities Act of 2003. We also have Article 41, which protects labor rights. Kelvin, are my slides still moving?
Yes, they are. They're moving properly. Thank you.
Thanks. Sorry, I'll keep on engaging so that I know you've not gone to sleep. Right. Oh, no. So great. So let's look at exclusion. This concept of exclusion of a person with a mental illness based on inherent requirement. Where are we getting this from? Section 5 of the Employment Act talks about, it is prohibited for an employer to discriminate, based on certain grounds, and disability being one of them. And of course, the employer is under an obligation to ensure that they put in place policies that would enhance equality within the workplace, Section 5. But then there's this provision, Section 5.4, that sometimes gives advocates who are representing, people who have been excluded or not taken for a job, nightmares, because it provides that it is not discrimination to distinguish or to exclude or to prefer any person on the basis of an inherent requirement of a job. Then Section 15.2 buffers that and says, an employer shall be deemed not to have discriminated against a person with a disability if the act or omission alleged to constitute discrimination was not wholly or mainly attributable to the disability of the said person, or the disability in question was a relevant consideration in relation to the particular requirements of the type of employment concerned. So in Section 45.2 as well, when we talk about unfair termination, a very interesting provision there is if the employer can prove that the reason for termination is based on conduct capacity, compatibility, or operational requirements of the employer, then it shall not be deemed unfair termination. So that's what I'm saying. Gosh, it kind of gives some nightmares to if you are, say, facing, a client who is saying, look, I've been discriminated against based on my mental illness, based on my psychosocial disability, and I want to, bring this matter to court. How do you answer this provision of law with regard to this permissible discrimination that the law seems to be giving employers? And the reason we're really asking about this is because for the legal profession, one would argue that it is actually an inherent requirement for somebody to be mentally fit, for somebody to have a level of mental fitness that is able to handle the adversities and the stresses of the job, right? And so if you do not have that quotient, we call it adversity quotient or whatever, then you may not be able to handle that particular job. So maybe in the chat, just to get us interactive, you could put your views as to what you consider, and especially for those who are in the legal profession. I do recognize that there are people who may be joining us who are not in the legal profession. But if you're in the legal profession, maybe you could give your views in the chat. What would you consider to be inherent requirements in the legal profession? Yeah, for example, as an advocate or as a judge or as a paralegal, because the legal profession is quite wide. Okay, what do you think are those basic requirements? In fact, to help you, we can look at the meaning of inherent requirement. It's not defined in the Employment Act, even if it's put there. It's not defined in the Discrimination Convention, even if it's put there. It's not defined in the CRPD. So we are relying on different principles from cases here in Kenya and also around the world. It's an indispensable attribute. An inherent requirement is an indispensable attribute which must relate in an inescapable way to perform that job, right? It's something that you can't remove from the job. It's a characteristic that you cannot remove from the job without radically changing the nature of that job. And it must be a permanent feature of that job. So what are these essential requirements of being in the legal profession? What are those inherent requirements? It would be good to hear from you so that as we continue the conversation, we can make a determination on the issue of mental fitness and exclusion of persons with mental illness. So some challenges that may be faced by a person with a psychosocial disability or a mental illness that can maybe even justify exclusion. An employer can use to justify exclusion. Difficulty in concentration, difficulty in focusing, restlessness, inability to block out sounds so you are unable to focus, difficulty maintaining stamina and energy throughout a full day, maybe drowsiness sometimes due to medication, difficulty coping with unexpected changes at the workplace, difficulty handling pressure and multiple tasking, meeting deadlines, difficulty interacting with others and socializing, and even difficulty with negative feedback and criticism, right? So the question then is, if you have an employee who is exhibiting this, they can't make it to work on time because they have difficulty waking up in the morning. They're usually very tired in the morning, or by 2 p.m. they've zoned out. They can't actually, even meet clients, say for consultation and things like that. So does that mean that this person does not meet the inherent requirements of the job? Yeah. Who determines? Is this a subjective determination by the employer, or are there objective tests that you can use to determine that inherent requirements have been met or have not been met, right? So it will take us then to the next concept of reasonable accommodation. Because one of the things that the Convention on the Rights of Persons with Disabilities provides, and which is also ingrained in our Persons with Disabilities Act, is this concept of reasonable accommodation. So for a person who has any kind of disability, including what we're talking about, psychosocial disability, the necessary and appropriate modifications and adjustments need to be made in the workplace. But these modifications and adjustments should not impose a disproportionate or undue burden on the employer, all right? But the issue is that something needs to be put in place, almost some form of affirmative action, that will help this person to be on an equal basis with others and so that they can enjoy their human rights. So I want you to note what I've underlined. Necessary, appropriate modifications, but not imposing a disproportionate or undue burden. I think that's the protection that the employer has. Yeah. It's something that both protects the employee and the employer. All right. And of course, under Section 15.2 of the PWDA, if the employer cannot be reasonably expected to provide those special facilities or modifications, then it will not be discrimination if they inform the employee that we can't hire you or we have to fire you. That's an interesting situation, okay? So of course, there's some examples of Kenyan cases where a reasonable accommodation was applied by the courts. I think you'll go through them in your own time. You know, I think the one that is really interesting is the Juliet Mongeli one, which, you know, I think that was one of the first cases which came out. But even having said that, I want to just note that the cases that have come to the Kenyan courts are on other categories of disabilities, you know, sight, mobility, hearing, and so on and so forth. So the issue of mental fitness and mental illness and disabilities has not really been tested in the Kenyan courts per se. But the issue is live, as I say, because there is the appointment of a tribunal to investigate. So I'm not going to comment on this matter too much. I just want to bring it to our attention to just kind of jog our minds. There's a tribunal that has been set up to investigate the removal of a judge on grounds of mental incapacity. Yeah, I'm sure we all know who it is. So when I was thinking about this topic, I asked myself, the JSC as an employer, you know, the JSC is the employer and it's petitioning. So it wants to fire this judge. But can the JSC be questioned on what reasonable accommodations it afforded the learned judge in order to carry out her duties when it discovered as an employer that there are some, you know, issues with regard to mental fitness? Was there reasonable accommodation given? I don't even want us to comment on it because it's a live matter. It's you know, the tribunal is going to sit and give us its report and so on, but it's just worth thinking about. So that if somebody was to take a matter to court to challenge discrimination based on psychosocial disability, what grounds would one be using? And how do you challenge the employer for not providing reasonable accommodation, particularly in the legal profession? So sometimes some of the reasonable accommodations are not so expensive for the employer. You know, allowing flexi hours, allowing time off for therapy sessions, extended sick leave, quiet and stress-free working spaces, you know, where there's minimization of distractions, perhaps even permission to work from home, where there's use of technology, you know, provision of psychosocial support, more breaks during the day, or even return to work strategies and rehabilitation. So some of them would not cause undue hardship. You know, some of these modifications and alterations would not cause undue hardship for the employer. So having said that, I'm now moving towards, you know, some of the challenges. And as I said, you know, we won't do justice to the issue of unpacking mental health policy and legislation because it covers a myriad of things which are, you know, beyond issues of employment and issues of exclusion and reasonable accommodation in the workplace. So one of the major challenges for us in this country is that we haven't fully implemented the rights-based approach, you know, to mental health that is now worldwide, you know, as a worldwide policy. And we are yet to really strongly move away from what is called the medical model of mental health care to social model. So the medical model looks at this person and sees you need to be treated. You need medicine in you for you to get better and for you to be able to cope in society. Yeah, you have dysfunctions that need to be dealt with by medications. And I think that's where a lot of people are, even when they look at employees, even within the legal profession, you need to get medication. But the social model is that the environment is responsible for the impact of disability on the person. And the environment should therefore be conducive and supportive. And this is where we want to take even employment policies with regard to persons with psychosocial disabilities. Other challenges I've put there, one of the major things is we don't even have a persons with disabilities policy. It's still in draft from 2006, we haven't gotten it yet. The mental health policy does not really address the issue of access to employment for persons with psychosocial disabilities. The amendment bill of the Persons with Disabilities Act of 2003 interestingly changed the definition of disability and has removed mental and psychosocial disability from the definition. So it's really lumped up with other impairments, which I think is really wrong for purposes of strategy. The task force that we talked about did not have appropriate representation from the lived experiences of persons with psychosocial disabilities and their challenges, especially in the workplace. And so the report, if you read it, does not even contain specific interventions for integration into the workplace for persons with psychosocial disabilities. And I think this is one of the disabilities that is very marginalized. We talk about others, the sensory, the audio visual, the mobility, but psychosocial is really dealt with, like that's a mental health issue, just let it be dealt with in that, but it should be dealt with really as something that can cause exclusion in the workplace. So what am I concluding by saying? In a capitalistic society, it seems easier for employers to hire and retain employees who are not problematic. We take an exclusionist approach. We just want to take those people who it's cheap for us to run with them. We don't have to incur extra costs. But this is against that rights-based approach that we were talking about, and an employer can actually be found liable for discrimination. The dilemmas are for the employer would be, and this would be a conversation I would really advocate for, to talk about the adherence to your statutory duty of care, your common law duty of care, to ensure that there is a safe environment, not just for that employee, but also for other employees, versus the duty to not discriminate. And then the dilemma is also with regard to staying profitable versus ensuring there's no discrimination. Yeah. So for suggestions for reform, I've just put there, which I just in the interest of time, you can go through them. We need some alignments at policy level and legislation, maybe even removing terminology that is demeaning. For example, a person of unsound mind, that is very demeaning, okay? Increase of financing, maybe pushing for subsidies for employers who provide reasonable accommodation, having tax breaks for employers who would employ persons with disability. Let's talk about the legal profession. What is the role of the LSK in enhancing the integration of lawyers with psychosocial disabilities into the workplace? I noticed in the strategic plan that is supposed to end this year, that one of the activities is to develop a strategy for mainstreaming disability and marginalized people's needs. I would like to really be educated on what exactly has gone on and whether there is actually anything that the LSK has done, particularly for psychosocial, psychosocial disability or mental illness within law firms. So I thank you very much for your attention. I've tried to run through, and I realize that even as a teacher, I can talk and talk, but thank you for your attention. Asante.
Thank you very much, Dr. Njuguna, for that very interesting and illuminating presentation. Before we proceed to our next speaker, I neglected in the flurry of the technical issues to actually properly let the participants know of Dr. Njuguna's bio. And so let me give that to you now. Dr. Naomi Njuguna is an advocate of the High Court of Kenya, our very own, from the University of Nairobi. She is based in Parklands campus. She's an advocate of 16 years standing. She has an LLM from the University of Manchester, recently defended her PhD thesis at the University of Leicester. Her thesis was a case study on psychosocial working conditions of healthcare workers in the public sector. She teaches labor law and health law policy and ethics at the University of Nairobi. Her research interests are in health rights, patient safety, labor law and occupational safety, and health of healthcare workers in low and middle income countries. Asante sana, Daktari, for your presentation. Questions have been coming in the chat, and if you'll allow me, we can give you room to ask those questions at the plenary after our next speaker has presented. Thank you so much, Daktari. Now, without further ado, let me introduce our next speaker. Our next speaker is also an advocate, a senior advocate of the High Court of Kenya. That's Mr. Charles Cindano Gakuru. He's an advocate of 19 years. He has consulted widely on matters pertaining to the drafting of laws and designing policies and programs in land use, agriculture, science, technology, and innovation. Presently, he is completing his LLM at the University of Nairobi in Environmental and Natural Resources Management Law. Senior Cindano speaks to us this afternoon from his first-hand experience with mental health setbacks. His candid reflections on social media have raised awareness on how close to home mental health setbacks are. As he will disclose, he has been hospitalized severally and been subjected to different modes of treatment. He's a living example of dealing with mental health setbacks, not giving up and staying productive. So without further ado, over to you, Senior. The floor is yours. Thank you. Is Senior Gakuru on the platform? Senior, are you there?
Yes, it's there, but it's muted. Kevin?
Okay. Kindly unmute your mic. Mr. Gakuru, kindly unmute your mic. I don't know if you can hear me. Let's see. Kindly bear with us, participants, as we try and sort out the technical issues. Mr. Gakuru, you are muted. I don't know if you have realized that. Okay, as we wait for Mr. Gakuru to sort his technical issues, maybe I'll just go through some comments that have been coming in through. We have had comments coming through from Hassan Salim, who's a peer educator from the Coast Region Changamwe Outreach Trust. And he says that this is awesome for a recovery addict. Working with you in a better nation. Hugs to all. Thank you very much for that comment. Again, I'd encourage the participants to please put your comments on the platforms, even as the presentation is ongoing, so that we can be able to put any questions you have to our presenters. So don't feel shy, it's a safe space. And any questions that you ask, we will attempt or do as much as possible to have them answered within this session. Those that will not be able to be answered can be answered at a later date through our social media platforms. Okay. Let me just check on our next speaker to see if he's on. Mr. Gakuru, are you with us? Are you back with us? He had been experiencing some challenges earlier on, and we had thought that he had resolved them, but it seems maybe they have persisted. Okay, perhaps what we can do then is perhaps Dr. Njuguna, perhaps we can maybe do a brief plenary review as we await Mr. Gakuru, as we wait for him to come back online onto the platform. I don't know if that is okay with you, or maybe taking a sip of water.
No, I'm fine. I can take a sip of water as I talk.
Okay, great. Okay, so thank you so much. So let me get some questions up. Let's see. We have questions from several people. I'm just trying to pull some of them up. So we had the comment from Mr. Hassan Ali. We have a comment, a question from Ms. Odongo. She's an advocate based in Mombasa. She asks, what do you consider to be an inherent requirement for one to perform their duties as an advocate? What do you consider to be an inherent requirement for one to perform their duties as an advocate? And she says another commenter has mentioned resilience and thick skin. But as advocates, I think we can agree that that may not be specific enough to implement when hiring and even when deciding whether or not to terminate employment. So what would you consider to be an inherent requirement? Because that might seem a little bit too specific even in certain cases, in certain sectors. Over to you, Dr.
Okay. Actually, it is me who posed the question to participants to put on the chat, you know. So I'm just exercising my mwalimu hat, you know, so that I can get, you know, participants to give me some of their thoughts, which we can have a discussion around. So I've only seen resilience and thick skin. I think there should be some other maybe requirements that you think that one would think is an inherent, you know, something that if it is not present within the job or within this person to be able to do the job, that the job cannot be done, you know. So for instance, let me give a non-psychosocial issue. So if in the job advert, the job advert says that we're seeking to hire a secretary who can type 50 words per minute, you know, or 50, I don't say 50 words per second because that's impossible, but 50 words or 100 words per minute or something like that, or even 500 words per minute. If somebody appears for the interview and says that, and is asked that specific question, are you able to type 500 words in a minute? And the person says, no, I can only type 200 words in a minute. If they exclude her or him, would that be discrimination? Is the 500 words a minute an inherent requirement of the job? Okay, let's look at another one. What about if it's a pilot who has a visual disability and who cannot see? Is that an inherent requirement of the job? For them to be a pilot, do they have to see? So that if they do not see, or if they cannot see, then the employer not hiring them would not be discrimination. So let's come back to our example. So an applicant is before you and is doing all the aptitude tests, and as the interview goes on, they actually disclose to you that I am diagnosed with schizophrenia, or I'm diagnosed with bipolar. I have bipolar. Would you automatically, as an employer, say, this person will not be able to cope, with the job in this law firm because it's an inherent requirement for somebody to not have a mental illness, for instance, So that was my question, and I really would have wanted, because there are many practicing advocates here, and there are many employers here, for them to give some more views on what they would consider inherent for an advocate or for somebody in the legal profession, or even for a judge. Evelyn is saying should not be a kleptomaniac.
That would be interesting. If I may come in, Dr. because perhaps because I even put a question up on the chat, because as I was listening to your presentation, it was really illuminating and made me think a lot of things. For example, we really use the word mental capacity or sound mind, as you rightly pointed, with little thought to it. We have become so immune to it now that we, even as advocates, just write it down and move on without thinking twice about it. So now, when the issues of inherent requirements, if in the scope of the legal profession, when job adverts are going out, I've never seen a job advert where they ask for anything close to or related to mental health issues. So those kind of issues tend to come out maybe at the interview stage, and some may be easier to spot than others, and those that cannot be spotted at the interview stage usually tend to be found out during the employment. So then it puts an employer at a difficult situation where you don't want to discriminate, but also it puts a prospective employer at a disadvantage, because what an employee might have just maybe short-term memory loss or anxiety sometimes, but would that be sufficient to deny them a position at your law firm?
Yeah.
Or to call them incompetent, for example?
Yeah, that's exactly what we are now discussing, because for inherent requirement, for something that should be an inherent requirement, the concept even of reasonable accommodation now comes in. And the question is, can this person still perform the requirements of this job should some modifications and adaptations be made within the workplace? So, for instance, the cases that I cited, where there's a visual, disability, can the person perform their functions, the operational requirements of the job, if they are provided with maybe the correct equipment or something suitable for them to? And if that is affirmative, if the employer can do that, if the employer then refuses to do it, then that is discrimination. So in the same way with psychosocial, disabilities, if the employer can actually provide that environment where they can give flexi hours, they can give a quieter environment for this person to work. So if this person is highly distracted or nervous around people, they can be told, you can still do the pleadings from home, and then send them on email, and they can be worked on. The issue is if the employer can do that and fails to do it or refuses to do it, then it can be deemed to be discrimination. Yeah. So these are the things I think that sensitization and awareness on discrimination laws, and particularly, for this marginalized form of disability, mental illness, psychosocial disability, I think people just automatically assume that a person with a mental illness is incapacitated, that there's something then wrong with their intellect. But this is not an intellectual disability. This is a mental illness, and this person with the right supportive environment, the social model, the right environment, can actually thrive and meet the requirements of their job. Yeah. So this is what I want us to think about as lawyers. Is there something? As we're talking, I was just trying to get some of the adverts, that go out with regard to, say, hiring of a commercial. This one is hiring of a conveyancing and commercial advocates. So let me just see. So of course it says, yeah, net salary, Then it says key responsibilities. So meaning that a job description is given to show the requirements of this job. You need to provide legal opinion on matters relating to property and real estate. This person with a psychosocial disability or mental illness, can they still do that? Yeah. Offer advice to clients on legal processes involved in purchasing and selling of property. Work to protect the interests of clients and ensure they are protected against fraud and money laundering. Conduct research to identify legal ownership of properties by assessing government land registry documents or title deeds if the land is not registered to anyone. Prepare lease agreements. Those are the requirements of that job. So that if you're not able to do this, then you cannot be offered this job. But then does it mean that somebody with a mental illness, somebody who at the interview says, I have bipolar, would that be a way of excluding them because they cannot perform these key responsibilities? I think not. In fact, if you do, you may be found to be liable for discrimination against that person. Yeah.
Thank you, because thank you for that, because I have a sister who has a visual impairment, and I feel when it comes to disability in general and perhaps mental health or mental disability, there seems to be a very distinct fields, if you like, for lack of a better term. Because, for example, my sister could get machinery, she could get apps that would help her listen and read documents, or rather the apps read the documents out for her, so she can be able to know what is in the document, so she doesn't have to strain herself trying to see something she really can't see very well. But then now, if you take it to the mental health side, I think also, with employers, not many people have really come into contact with people who have mental health issues, or if they have no idea. So the example of what you gave, bipolar, even people with autism who may be as sharp as as sharp as a pin, but maybe the way they present themselves might be distracting for some, uncomfortable for some, so that now employers find themselves thinking maybe they're a good worker, but there's something, they're distracting because maybe they stutter, or maybe they have something like that, which then could potentially make an employer at risk of acting in a discriminatory manner, because there might not necessarily be a way to accommodate it the way you could accommodate someone who has a physical impairment. You can create ramps, you can create easier access to rooms. Someone who has visual impairment, you can have use technology to assist them. But with mental health, I'm not very aware, maybe it's just my ignorance, but of maybe ways or legitimate ways, realistic ways that an employer might be able to accommodate that. I don't know what you might say to that.
Yeah, and as you're talking, you know, one of the things, you know, reasonable accommodation, for instance, is a cost, you know, of some form to the employer. And of course, you know, I think it might even be cheaper sometimes to buy equipment for somebody who has a mobility or an audiovisual disability than to allow an employee time off from work. It might actually be cheaper to buy the equipment than to allow an employee time off from work to maybe attend, you know, clinics and therapy sessions, or even when they have an episode, or you know, that they can, you know, maybe just say, I need some 3-4 days off work because I am experiencing, you know, an attack of some form and so on. And because to the employer, it means that they're paying this person maybe the same amount of money, because you cannot discriminate on that, same amount of money, but they are working maybe less hours. They are working, you know, in a way that is different from other colleagues in the workplace. And, you know, you have to give them this accommodation. And so in a capitalistic society, as I was saying, you know, this might be a very tall order, you know, for people to even understand and grasp. And that's why, you know, this kind of, issue, mental illness in the workplace, is something that we need to have more and deeper conversations about it. And particularly because, like in my thesis, I bring out the issue of these mental issues that are as a result of the working environment itself, you know. So it's not somebody who is coming in with an issue, but that issue has come up because the working environment is so stressful, you know. It's just unaccommodative. People are losing families because they are ever at the workplace. They're losing sleep. You know, we know people who have committed suicide. The young man who fell to his death, who had been working through the night, went home, I think only for 2 hours, and then came back to the office. And, you know, lawyers are workaholics, you know, and these are issues we need to talk about and say, can the employer even be liable in negligence, for instance? You know, duty of care, breach of duty, and you know, resultant harm as a result of breach of duty. Can an employer be negligent if an employee is facing these mental issues as a result of the working environment that is provided for them? Kelvin, you and I are lecturers at the University of Nairobi. Okay, you're not a Parklander, but Parklands, we have in 1 year perhaps, or even one semester, I could be teaching 2 units, labor and health, for instance. And the number of students, say in my labor law class, would be, in one class, say the day class would be, say, 250. And then I have the regular class, which is 200. And then I have the evening class, which is 180. So teaching is fun, you know, I can teach and Then come marking, right? Marking, I'm being told you have to mark within, 3 weeks, 2 weeks, and the semester is starting. And so there's this pressure. So the working environment is actually causing me stress, depression, you know, things which I don't really want to feel, depressive disorders and, you know, things. I can even start doing substance abuse, God forbid, you know, but this is it, you know. And so can an employer be found liable for, you know, breach of duty of care if the environment is not conducive? That's one. But the other is, you know, the issue of the hiring and not providing the reasonable accommodation for this employee, and then in telling them, we are sorry, we cannot hire you, or we have to let you go because we cannot afford, you know, we cannot afford. So there's issues of evidence. When it comes to court, you must prove as an employer that surely it was too burdensome for you. You know, these are issues, evidentiary issues. You've got to prove it, that this provision of modifications and alterations was too expensive for you. You can't afford it. So say if you're a one-man show, you know, a law firm is a one-man show, and you really cannot afford to have that kind of arrangement, then it would not be unlawful for you to actually tell the person, you know, I cannot afford this. I cannot provide quiet space for you. You know, my office is just this one room. And, you know, as we go on, the COVID pandemic has really affected many people that they've had to even sublet offices and things like that. So their working spaces are smaller. So, you know, I'm sorry, I cannot afford, you know, to actually allow too much time off. There must be a limit, you know, to the time off. Otherwise, I'm going at a loss. Yeah, it's too burdensome for me. So these are the things that need to be discussed on a case-by-case basis. Yeah, sorry, I'm talk too much. Yeah, thank you.
No, not at all, Doctor. I think and just as a testament that you're not talking too much, I was just going to first of all remind our participants, please put in your questions to the chat. We would like to have everyone speak, but it might become a little bit out of control. So we are just having the chat function so we can be able to properly funnel the questions to our speakers today. So we have Daktari, there's Franklin Singoe, who's saying, great discussion going on. My concern, even as we discuss mental fitness at the workplace, I tend to think that we are addressing the symptoms, but not the causes. My question is, are law firms ready to offer home care for the younger advocates or their employees, or they should continue sticking to delivery requirements? So I think you had even touched upon that as we were discussing just a second ago. We also have a comment from Ms. Odongo, who's saying, should an employee diagnosed with a mental illness be obliged to disclose this to an employer, knowing what the consequences may be? Now, this is another aspect perhaps to this, where you know, medical information, is that qualified information that needs to be disclosed, the way you might have to disclose that maybe you have you know, certain allergies, maybe if you're working in a food environment, or certain predilections which might make it maybe dangerous, maybe inconvenient, maybe cumbersome for you to be employed with an employer. So putting that in the mental health discussion, whether an employee diagnosed with a mental illness should be obliged to disclose that, and what would be the consequences if they didn't disclose it and something happened because of that, that could be attributed to their mental health situation. Also from Jill Baraza Daktari, who's saying, I'm loving this discussion, and she's mentioning the Mindful Business Charter is a great start that I hope will be taken up by other sectors. Perhaps maybe you can give us your view on the Mindful Business Charter, because also I think also what Ms. Baraza has highlighted is that it could be also a sectoral issue, where certain sectors might be better equipped to accommodate employees with mental health conditions or concerns than other sectors, where, let's say, you know, I can't even really think of a good example, so let me not try. Also, we have Eric Nyahurenya, who's saying, glad to be here. I'm learning a lot, and I'm happy to see my labor law and health lecturer, Dr. Naomi. Also, we have Dr. Mercy Deche, who's saying, thanks, Doc. What would you say about the intersectionality of mental health and other vulnerabilities like gender and age at the workplace? And also, as I pose that to you, I'm just getting word in from my imaginary inner ear speaker that Mr. Cindano Gakuru has gotten back on the platform. Karibu, Senior. So perhaps maybe let me give Daktari a break so she can ruminate on those comments and questions. And I can invite Senior Gakuru to give us his presentation. Welcome back, and pole sana for the issues that you've been experiencing, Mr. Gakuru. Welcome.
Thank you very much for having me. Can you hear me?
Yes, we can hear you loud and clearly. Thank you.
Yeah, right. Thank you very much. Poleni sana for the small technical hiccup I suffered. I'm glad that I found you. My experiences with mental health started way back when I was studying medicine, and that was in 1994. I sort of managed it with the help of my doctors. I had to change courses, of course, to law, Parklands, where I completed my LLB without any issue. Then it hit me again in the course of my practice. Fortunate enough, I was not working for someone. I was working under my name. So apart from being labeled as a miscreant, someone who is erratic, nothing much happened between those who would employ my services. As a consultant and drafting some few laws and policies, these were done in the form of yes, workshops. So you would go somewhere for about a week or so, and then go back to existence, yeah, to normal existence, and that didn't prove a problem. There was a way I could manage my episodes, if I could call them that, yeah, and they didn't affect my productivity. The only issue would be, if we are thinking hypothetical, if I was involved, if I was employed I think I would have been sacked. I think the first or the second week, because of there are times when I am one of the biggest things about depression is the lack of motivation. You slowly grind to a halt, and nothing moves you. Colors don't move you. Music doesn't move you. Everything becomes tasteless. Right? It's like that pillar of salt. The biblical one, when you look back and you turn it up, life turns out to be that way slowly, and then the usual way would be for a human being, the usual emotional regulation would be that for every up there's always a down, and for every down there's an up, right? If there's anything that is causing you to have negative emotions, it is only there for a period of time. If it's grief, you say a week or so, and you would bounce back. But not in the case of some of our conditions. We tend to slide all the way to the bottom of the hill. There's no way of climbing up, and there's no way of stopping us, because one question will lead to another, right? And it will lead to another dimension where you keep on falling. So, for example, I'll give you an example. If I was employed and my boss came and told me that he's unhappy with the way I presented or the way I drafted an affidavit, for instance, something as innocuous as that, the usual thing would be I would bounce back and say, let me do it again. Let me find out what it is that I should have done. But with these conditions that we suffer from, it will lead to the next question. And the next question will be, am I worthy being called an advocate? And it will now lead you to another set of questions, is what the hell was I doing in college? What was I doing in college? And then it will lead now to the next dimension, I mean, still lower, right? To the next set of questions is, I'm worthless. I am, and then later on you say, look, I'm even a pain to my employer. I'm doing shoddy work. So now that's what happens in some of our mental instances is that when any negative impact, whether earned or not, right, we would hit rock bottom quite quickly, quite rapidly, and it will take us a while before we won't even have the, okay, when it comes to major depression disorders, we don't have the capability of producing the requisite hormones that would help us crawl back into normal existence. No, we tend to remain at the bottom. And this is what happened to me in the year 2007. I hit rock bottom and I decided, now let me make myself comfortable here, because it's becoming such a tedious task to crawl up. Let me remain here and then look for the devil. This is actually what happened. Look for the devil and ask him, what does he want to do? What does he want to do with my life? Why is he so in? Because nothing seemed to be working. From having things working my way, starting a family, starting a law firm, being called up for consultancies in drafting laws and drafting policies. Then suddenly everything went quiet, and I was there alone with my thoughts. In the background, I could hear my little boy and my little girl crying. Oh, you want this and you want that? Yes. So those are the small episodes where you can be pricked into existence. Then after that, you would go into a slippery slope. And the worst thing is that okay, another disadvantage is that at that point in time, you may have someone by your side, but it is so difficult to tell them what it is that you're going through, because it's difficult to explain. It's an experience like, say for example, you are a tenant and you haven't paid your rent for a period of 2 months, and you hear a knock on the door. Immediately, all your hormones will pound. The anxiety will go up. Say, who is that? Is that the landlord? Is it auctioneers who have come? I mean, is it what is happening? Now imagine having that and there is no way back. It's the anxiety of, and it piles up and goes on for a period of 2 weeks, 3 weeks. So these are when we're talking about the law and policy, some of the difficulty in addressing these issues is the science behind it. Trying to understand what it is that goes on in the mind, in the brain, is difficult enough. Now coming up with solutions, or coming up with a set of rules that would facilitate someone bouncing back is not only difficult, it's like asking someone to go beyond their duty, their call of duty. Because why would, if you look at the pure Calvinist approach to labor and approach to enterprise, is that employees sell their labor and get paid at the end of the month. They're never paid in advance. It's not like rent where you pay in advance. The employee, you pay their salary after the month. Now, the most the employer would want from his team of employees is to do exactly what it is that was they signed the contract for. So in my case, I may be artistic, I may be, when I'm productive, right? I could be the goose that lays the golden egg. But when I slump down, I'll slump down for about 3 months. Now, holding that into forcing an employer to take care of my needs for those 3 months is something that is difficult to even justify. This is when we now look at the social constructs that would help in either the family, or if you're talking about contractual basis, then you look at for insurance. And then if we have an insurance cover that takes care of the period in which when I am not productive. That could help, but then again we run into the difficulties of interpretation of terms when it comes to the insurance cover. So with that said, I thought that was it, that my 2007 was it. But I did not know that I was in another spell of depression, and it lasted from 2007 to 2019. That's a long period. And if there was anyone who was near me, would get I was nasty, I was cantankerous, I was a belligerent fellow. I wasn't eating, so I shrunk to I think half of what I am now. And at that time, my productivity was in the negative. I became destructive. And when I rushed to hospital, because I found that I was going to do something else, I rushed myself to hospital. I was not given medication. I was taken straight into ECT. That's when they pass some electric shocks through your brain, more or less like if you consider an analog would be if your smartphone is giving you problems and you try to install this, then work, you go to factory settings. So but the ECT is an example of that, where it flashes the brain so that now you can model your happy neural connections, your emotional regulations. You actually build yourself afresh. And it has been a year since my hospitalization, and I'm under medication, and I can actually feel a difference now. The things that would trigger some emotional outburst or a slippery slope down the murky ways of depression are not. So right now, if I was to seek employment, I would be very productive. Until then, the next episode, the thing is, once and this is what I was told by my first psychiatrist, is that your mind is like a glass, and once it falls, the most we can do is piece it back, but it will still not be 100%. It will be like a vase, a pieced up vase that can contain, it can do most of the work a normal vase would do, but don't expect it to be 100%. Those are not very encouraging words, but those are the words that we have had to live with. So I was reading the other day about it, and one can easily say that I qualify for disability, but now proving that my negative emotions are a notch higher than an ordinary person. Now that's when the science would come in, hopefully, and the science that would then inform the rules and regulations and our policies in helping us become useful members of society. I hope I've answered some of your questions. Kevin?
Thank you so much. Yes, I'm here. Thank you very much, Senior. Thank you very much for your presentation. And also, Pole Sana, I can understand the stress that you must have gone through, because I went through the same as I was trying to log onto the platform. So Pole Sana for that. But thank you for coming back and pushing on. So what I wanted to do, we had started a bit of a plenary as we were waiting for you to settle the technical issues that you are undergoing. So I'd like us to continue with some plenary, because the questions have been posted on the platform chat, which I'd like to pose for both yourself and Dr. Njuguna, if she's still on. Dr. Njuguna, are you still there?
Kabisa.
Yeah. Fantastic. So now we're into the plenary proper. So let me just put a couple of questions to you both. So what I started to bring up earlier was perhaps maybe if you could, Dr. Njuguna, highlight what the Mindful Business Charter is for the participants, or at least what you can let us know, so that we can then all go back and do our research as we are prone to do. And then also a question to Senior Gakuru. There's a question that I saw here from Ms. Benjamin Njoroge of Mombasa Law Society, former chair of Mombasa Law Society. And he says, Karibu Cindano, could you let us know the history behind your name? It's giving me a bout of nerves. In my mother tongue, it speaks of pain. So perhaps maybe we can start with you, Senior Gakuru, while you're still fresh, and then we can go to Dr. Njuguna. Over to you, Senior. Over to you, Senior. You're still on mute. There you go. We can hear you.
All right, thank you. Thank you for the question. There isn't any direct answer to to your question. It's a small history. My grandfather was adopted. The long and short of the story was he was adopted by a Digo family when he had trekked all the way to Mombasa. That was during the time when we used to have long distance traders. So my grandpa traveled all the way to Mombasa. He was converted to Islam, and he was given the name, he was baptized and put Ali Cindano. And when I was born, well, this is what I'm told, that when I was born, he insisted that I will be called Cindano, so that we can remember how he used to travel to the four corners of Kenya. Yeah, so I'm from this Mount Kenya, Central Amakikuyu, but with a Digo name. I hope that answers your question.
Thank you very much, Senior Gakuru. I'll give you a couple of minutes while Dr. Njuguna, I come back to you to maybe illuminate the participants on the Mindful Business Charter. So at least us as advocates and employers and employees, we make ourselves aware of what is the detail behind the Mindful Business Charter that we can carry on to our workplaces. Over to you, Dr.
Okay, thank you. So thank you, Jill, for flagging that website. Is it Jill or is it Evelyn? I think it's Evelyn.
Yeah, it's Evelyn. Yeah, and also Jill commented on it. Yeah, both of them.
Yeah. So I think the way that I understand the Mindful Business Charter is it is a way of organizations reducing stresses in the workplace so that the mental health and well-being of employees is enhanced. Yeah. So what I was talking about, mental fitness and the fact that it is related to the job requirements and the working environment. So this charter is, it even has a toolkit, and a way of organizations committing to reducing, work-related or unnecessary sources of stress, if you want to put it that way. I think it was a collaboration at first between law firms, banks, but it can actually be cascaded to all other sectors. Yeah. So I don't think it's a Kenyan innovation, but it's an innovation that we can use. So I think maybe in another forum, we can actually have a discussion, because I think one of the things that needs to happen is sensitization and awareness, within the legal profession as to how to reduce these stresses and also to reasonably accommodate employees who have these challenges. The conversation, I think, cannot stop here in this forum where there's limited time. We may need to have another forum. Yeah, but thank you, Evelyn, for putting the website link there, and I think we can all click on it just to have an idea. Yeah, thanks.
Thank you so much, Dr. I see we're a little bit pressed on time, so I'll just keep this brief. So I'll just maybe put another couple of comments or questions from the platform. I see Eunice Zhao, who said, thank you very much for the insights. An employer has the burden of proving that they had accommodated the employee by having mental health policy in the workplace. So that's a concern of hers. So maybe if both presenters could say something about that. There's also a comment from Christine Kipsang, who's the deputy chair of the Mombasa Law Society, who says, so timely, good discussion. Jacqueline Mudhoni says, great presentation. We have Helen Shiundu, who says, thank you, Senior Cindano, for sharing. This is so timely. Actually, this is happening in many law firms, but as lawyers, we're not ready to talk about it. I had a similar experience in my first job after admission, and I didn't know where to seek help. It took time, but I'm glad I overcame it. So these are, testimonials from people who are lawyers, advocates, who actually have also had to deal with mental health issues in the workplace and might find themselves without having anyone to turn to or resources. Certainly, definitely not in the past. Maybe in the last 5 years, things have improved, but still there's a long way to go, in my humble opinion. So over to you. Maybe you'd like to maybe comment on, at least the employer's side of it vis-a-vis the employee's side of it, in terms of how to tackle mental health issues in the workplace. As employers, what should they be thinking of, and as employees, what should they expect, or what should they be mindful of, or what should they be reasonably expecting from the workplace? Over to you. Perhaps Senior Gakuru, you might want to start.
Well, it's LSK would be a good starting point to champion the adoption of mental health policies for law firms. Well, if we are more or less trying to shift the thinking when issues that would render someone incapable of continuing in unemployment and get sacked are then seen in a different light. If with the help of many who are involved in policy drafting and policy sharing, LSK would be the right place. I'm also thinking, when we are talking about LSK, we are segregating. We should even have a policy with FKE, where all the employers and even KM and KOTU, where we are trying to create an environment conducive to work, and not looking for people to cogs in the wheel to bring in, to continue with the grind of production. And these kinds of initiatives are going to be premised on the fact that it is a growing science. We are now getting aware that many more people suffer from episodes of mental disability, and that if the environment is cranked in a way so that to allow someone to get back onto their feet, it would be better than just simply sending them away and telling them we do not have any more use for you. I'm happy that we're also having this discussion, because it's not a discussion that we could have had say about 15 years ago. No, because if someone's saying that is mentally ill, you're telling everyone that please do not employ me, or please do not work with me, because there will be a time when I'll flip. So and since and there's a thing that we have to accept, and this is something that can help, is acceptance that the sciences, the psychosciences are still in their infancy. There's still a lot that has not been unearthed. What are the conditions? Is it genetic, or when do is it the morphology, physiology? Is it the hormones, right? Is it an external experience, an encounter, or is it a blend of the three? So bearing that in mind, we would be well advised to be very flexible in coming up with examples of things to do.
Thank you very much, Senior. Daktari, anything to add on that issue, on what employers should look out for or consider, and also what employees should reasonably expect?
Yeah, I think I flagged quite a number of things in my presentation, but maybe just to pick up on something that Senior Cindano has brought out, the issue of assessments. That in fact, what we're discussing today about exclusion, or even leave alone exclusion, but reasonable accommodation, that principle of reasonable accommodation is at the moment in our jurisdiction right now only available to persons with disabilities and persons with PLHIV, persons living with HIV. According to the ILO, there's an ILO convention and practice direction on reasonable accommodation for persons with HIV. So if somebody has a mental illness which has not been classified as a disability, that is a very precarious situation for that employee. And that goes back to the question which you are asking about whether somebody should disclose whether they have a mental illness or not, from the onset. And again, I say, they are under no legal obligation if that particular profession or work does not require it, does not require for you to undergo mental fitness checks. But you see, disclosure can then help the employer to make certain decisions concerning any accommodation they would give to you. But so for employers, and I know that being now, like if I was, on an advisory board for an employer, I would say that unless this person has come with, if they have said that this is a disability, then you would be obliged by law to make reasonable accommodation for them. But if something has just been diagnosed, and that is what Senior Cindano was raising, that how do you move from mental illness to disability? It's a challenge. it's a very big challenge because so many assessments need to be done, so that if it's temporary, if something is temporary, it might not be termed as a disability. But you see, that would then also give more impetus for the employer to hire this person and to make reasonable accommodations, because it's only temporary and it's not something that is permanent and going on. So I think each case needs to be taken on its own facts. The things need to turn on their own facts. But the general principles, I think, are what we have just discussed. Yeah. Thank you.
Thank you so much, Dr. Njuguna. So as we are, for the benefit of the listeners, the participants, we are now winding down. Perhaps some final thought from each of you as we come to a close. What would you like the takeaway to be from our discussion today on mental health in the workplace, and especially as it pertains to lawyers and advocates in the profession? Dr. Njuguna, what would your takeaway be? If people forget everything else, what should they not forget?
Yeah, I think what we should take away is that for persons with mental illness in our profession, the legal profession, if we don't even want to think about the law or anything, I think compassion is a key thing that we need to practice in our profession. And with compassion, we would be able, not to look at the nitty-gritties of the law and look at how we are going to escape liability, but look at how we are going to assist this person, because work is a way of getting a person to be self-fulfilled and to self-realize. So allowing them into the workspace, I think, is something that we need to think about seriously as lawyers in the legal profession generally. And I'm really watching to see this tribunal issue and how they handle that particular case. Yeah. Thank you.
Thank you. So am I. I'd like to see some changes and some real action behind the words that have been put towards supporting mental health and mental health initiatives in the workplace. Sorry, I beg your pardon. Senior Gakuru, are you around? Are you still there? Okay, I think there might be another technical issue, but as he gets finds his way back to us, I'd just like to take this opportunity to say thank you so much, first of all, to our listeners for their patience and attention throughout our webinar today. We have been a little bit plagued by technical issues, but we have forged on and had a really good discussion, and I hope everyone has had something to take away from this. I'd like to thank personally and on behalf of Mombasa Law Society and the University of Nairobi Mombasa campus, our speakers today, Dr. Njuguna and Senior Gakuru, for taking the time out to come and share their knowledge and their insights with us today. Before I move on, I'd like to hand over to our senior here in Mombasa, that is Mr. Benjamin Njoroge, to give a vote of thanks. Mr. Njoroge, are you there? Mr. Njoroge? Mr. Benjamin Njoroge, are you there? As I'm waiting for him, I'm just seeing some more comments coming up. Benedetto Cheng, I said informative session, asanteni. We have quite a few messages that are coming in. Senior Njoroge, yes, I can see you. Kindly unmute. You're on mute. You're still on mute. Can you hear me, Senior? You're still on mute.
He's asking that you unmute him. Yeah.
Oh, I've understood. I've understood the assignment. Let's see. My apologies. think Simon Wangi, perhaps you could assist us with unmuting Mr. Njoroge.
Oh, now I think.
There, I can hear you. I can hear you now. Yes.
I am.
Please
okay,
go ahead.
So thank you very much. I think all I would wish to say is thank you, Daktari and Senior Cindano, for the engagement and the thoughts, and especially the candid conversation that we've had today. It's always fresh when it's coming from within ourselves, and when we're addressing the issues that are very dear to us. The other day, I sat down with an old classmate who has faced a few challenges in life. And he mentioned to me that a psychiatrist told him that mental health is similar to any other issues of health that afflict the body. So such that if today I was to break my leg and get a fracture, you would say that I am sick and I need assistance or medical assistance. I would not cease to be a lawyer because my leg has fractured. And this particular doctor was saying that even the mind gets sick, but once the mind is treated, you would expect some recovery and the person goes back to a situation where they're able to do the things they're able to do. So we are fortunate in Mombasa in terms that we come from a bar that is very accommodating. Perhaps not unlike some other bars that I have practiced in. So we tend to care about each other and for each other. In the world that we are living in currently, especially the digital and the virtual world that we are in, you will find in as much as we enjoy the efficiencies that come with virtual courts, they're also very stressful or very stressing. And it is helpful when we try and introspect and follow some of the advice that Daktari has said, that we have to be accommodating in our profession. It doesn't help when you appear in court before a judge who is very harsh or very rigid, so that if you fall out of the platform, the next time you log in, very adverse orders have been made. Again, it also doesn't help when you appear before in a court with a colleague who really does not wish to accommodate you. If today if we were to apply those guidelines, the rigidity that sometimes we see ourselves applying out there in court, we would not have been able to listen to Mr. Gakuru, and we would not have been able to benefit from the information that he has given us. So it is up to us to be each other's brother and sister's keeper. I welcome you again to join us for future public lectures. Daktari, you've given us a challenge. I think this is the first. We need to do another one. I'll throw the challenge back to Dr. Sarah. Perhaps we can do it before very long. And we can all benefit from the conversations that we need to keep on going. We are all looking forward to see what the tribunal that was set up delivers. And I know it will impact on how we handle ourselves going forward. So thank you very much, and karibuni. Back to you, Kevin.
Thank you very much, Senior, for the vote of thanks. I'd like to second and echo everything that our Senior has said in giving thanks and in also putting what has been presented today in context. So in conclusion, I'd like to thank all our participants. Thank you very much, Asanteni Sana, for joining us this afternoon. Let us keep this discussion open and ongoing. Let us engage on social media and also in your personal capacities amongst each other as professionals and with your families and colleagues. We have come to the end of the live session today. Thank you so much for your attention. We'd like to apologize for the technical hitches that we've been experiencing today, but thank you for bearing with us and coming with us through to the end. So please note that the recording will be posted in our respective websites and social media handles for more discussions on off-air rather. So please look out for that. And I hope we've all been inspired to be agents of the change that we seek. So for now, just to say goodbye, kwaheri ya kuonana, adieu, and until the next public lecture. Have a very good Wednesday evening, everyone. Thank you and goodbye.